This program is brought to you by the Georgia Neurosurgical Institute. For over 50 years, rendering neurosurgical care to patients of all social conditions, treating complicated problems involving the brain, spine, spinal cord, and peripheral nerves, endeavoring to encourage quality care, medical research, innovation, and education on a local, national, and international basis.
Good evening. My name is Joe Sam Robinson. It's our pleasure to have with us tonight Judge Dillard of the Georgia Court of Appeals. Welcome, Judge.
Thank you. Good to be here.
Now, we'll just sort of have a little discussion tonight about how the appellate system works in Georgia.
Sure.
So before we do that, let's see, how does one get to be a judge? That sounds like a pretty big responsibility. How does that happen in Georgia, that you become a judge?
Well, that's a great question. And interestingly enough, there are some judgeships in Georgia that you don't even have to graduate from law school.
Oh, really?
In order to do that.
Is that right?
Some probate courts in smaller, more rural areas of Georgia, you actually, I think you just have to be a high school graduate.
I think, is that true with the U.S. Supreme Court?
No, that is not
true.
You're
sure? Do you have to be a judge?
That's true. You do not. The only position in the federal government that requires you to be, quote, learned in the law is the Solicitor General position.
Right. Otherwise, it's okay.
That's true. But as a matter of practice and a matter of recent history,
of course.
They've always been obviously highly qualified graduates from law school, and usually former judges or judges on intermediate appellate courts, which is where I'm from. But so how did I become an appellate judge?
First, you went to law school.
I went to college. I was a history major, journalism minor at Samford University, and then I went to the Mississippi College School of Law in Jackson.
Yes.
Did well there, and got an interest in appellate advocacy, won a competition, got another award, and just started thinking about that might be something I wanted to do.
Yes.
After that, I moved to Georgia, was in private practice for about 5.5 years with a law firm here in town called Stone & Baxter.
Yes.
Took a 2-year hiatus from practicing to clerk for Judge Daniel Mannion on the 7th Circuit Court of Appeals in Chicago.
Now what is a clerk?
A law clerk is an assistant to the judge that actually helps with research, with the drafting of opinions, basically anything that the judge does on a day-to-day basis, processing motions, just someone to serve as an assistant to helping the judge in carrying forth or executing his judicial
Now these positions are highly sought after. Is that an understatement?
When I told folks that I was leaving a firm where I was getting ready to be made a partner to go be a law clerk, it doesn't sound it doesn't sound very impressive, but it is. They are very especially at the federal circuit level where I clerked. Those are highly coveted positions, and actually the only position that would be more highly coveted would be a clerkship at the Supreme Court of the United States.
Yes. So a big deal. So you had that experience.
It is. I had that experience. I came back to Macon.
How was that? I mean, you were at an appellate court division, federal appellate court division. What were you? And you had this job, and you were. It must have been pretty high pressure. A lot of important issues you were opining on, or at least contributing to.
That's right. I mean, anything from challenging the constitutionality of a local ordinance, banning alcohol at a new dancing establishment,
that could happen,
to a DFACS investigation of a private Christian school for using corporal punishment. We had all sorts of really fascinating constitutional questions during my time as a clerk for Judge Mannion.
And you were there for how long?
2 years. Actually, it's normally a 1-year clerkship. Judge Mannion is a little unusual. He will not hire somebody straight out of law school. He wants you to have a year or two of experience.
Yes.
And he also he likes to stagger his temporary, you're always a temporary appointment because you're not a permanent.
Yes.
It's anticipated when you come into the system you will only be there for a year or two.
Yes.
And usually 2 years is about the most at the federal appellate level.
Yes. So then you were there, you had an interesting experience, and then what?
Wonderful experience with Judge Mannion. I came back to Macon, Georgia, joined the law firm of James Bates, Pope and Spivey, now known as James Bates, Brandon, and Groover.
Yes.
And I was the chairman of the appellate practice group there.
Yes.
I did complex litigation in appellate practice and was with them from 2003 until the end of October 2010 when my appointment to the Court of Appeals was announced. Governor Sonny Perdue appointed me to the vacancy created by Judge Deborah Burns' tragic passing.
Yes. So you got that position. Now, judges are elected in Georgia, are they not? Or so what happens? You then go.
They are. So if there's a vacancy, the Constitution requires actually the governor to make an appointment.
Yes.
And so there was a true vacancy. Like I said, Judge Burns passed away. So I basically was given a term through the end of 2012. So I had to run in the next general election, which was in 2012. So I did that. I was unopposed. Received about 1.3 million votes. I'm statewide.
Well, that's good.
So I'm on the ballot from everybody from Bainbridge to the up in Blue Ridge. Everybody gets to vote for me in Georgia. I'm the first statewide officer from Macon in about 50 years.
Well, kudos to you, Judge.
Yeah,
kudos. That's good. Well, that's a nice
it's nice
thing.
for Macon to have a little.
Yeah, that's good.
A representative or ambassador up in the big city.
That's a rather good story.
Atlanta.
I hope you push the charm button appropriately up there and under the.
I try to do what I can for Macon.
Well, that's good. Well, so in doing this, in general, is that the way the thing works at the state appellate level around the country? Or people have lifetime appointments, or as they might in the federal judicial system, or they have elections, or how does that work?
It varies from state to state. You have some states that have what are called, you have appointments and then you have retention elections where you don't really have an opponent. It's just kind of an up or down vote.
Yes.
You have other states like Georgia where it is a nonpartisan, so we don't run as Republicans or Democrats, which makes sense because
you want to be
we want to be apolitical,
yes.
nonpartisan. So that's great. Now there's some states like Texas and Alabama and Mississippi where appellate judges actually run as Republicans and Democrats.
Yes.
I'm not a fan of that system.
Yes.
I'm not a Republican judge. I'm not a Democratic judge. I'm just a judge.
There you go.
And I believe very strongly in that.
So I think that's one of the things about the American democratic system, at least in Georgia, the idea that maybe earlier, or I'll ask that question, were judges always elected in Georgia? Or
judges, there's always been this mixture of appointments and judges are to be elected, but a lot of times they are running for election after being appointed.
Yes.
And there's always some tension there about that because the idea is that Georgia, from its very beginning, wanted judges to be accountable to the people.
Yes.
And I think we are.
Yes.
Now, we don't always get the interest being a down ballot race, but one of the things I've tried to do is to go speak to Rotary clubs, to speak to lawyers groups, or any civic organization that wants me to come and talk about the important role of the Court of Appeals and the Georgia appellate system and as far as preserving the rule of law in our state.
Well, you have your chance tonight, Judge, if I can say that.
Absolutely.
It's a slightly different venue, but so the Court of Appeals is there, and where does it fit in the appellate process in Georgia? How does that work exactly?
The Georgia Court of Appeals, of course, we have both state and federal courts in Georgia.
Yes.
So we have federal district courts, and then we actually have a federal circuit court, which is headquartered in Atlanta and covers 3 states, all the appeals from Alabama, Georgia, and Florida, and then after that you have to go to the Supreme Court of the United States. We also have a state system. We have all sorts of trial courts. The most well-known trial court in Georgia is called the Superior Court.
Yes.
My friend Judge Tripp Self is a Judge Vera Colvin, Judge Ed Ennis, Phil Raymond. They are all, and Howard Sims, they are Superior Court judges. They handle kind of the major criminal felonies. They handle domestic cases. Then you have state court judges where you handle some of the criminal misdemeanors and some of the big civil cases. Probate judges I mentioned. So all of these civil, magistrate, all of these courts, the question is what happens if you lose at that level? Now some of the lower ones actually have an appeal to the Superior Court.
Yes, right.
The ones from the state and the Superior Courts and some other trial level, they come up, some go directly to the Court of Appeals, which is my court. Some actually jump us and go directly to the Supreme Court.
Yes.
That's one of the things I'll get to in a minute, where we're actually addressing whether some of those cases that go directly to the Supreme Court ought to come to us first.
Yes.
So the Court of Appeals, we handle about 80 3% of all the appeals in the state. We are, in essence, the court of last resort. If you come to us and you lose at the Court of Appeals, you then have to file what's called a writ of certiorari to the Supreme Court of Georgia. You have to ask permission and say, hey, you need to take a look at this case. And it can't just be the Court of Appeals got it wrong. For the Supreme Court to weigh in on a case like that, it has to be the Court of Appeals got it wrong, and there's some pretty drastic implications because they got it wrong. And you need to step in and fix it, because it's not just important in this case, it's important in other cases down the road.
Now, we have a federal system here, and just for a lay person just looking at the arrangement here, some cases go into the state court system, and then and some go into the federal court system.
That's right.
What would be the reason that a particular case would start down that road? Why would a particular legal issue pick that particular venue?
Well, one reason you might go to federal court is we have what are called diversity cases. And so you might have somebody from another state who is injured here in Georgia or who causes an injury and they're dragged here to Georgia. And they may say, I want to be in a federal court, not in a state court, where at least the perception is, you know, there's going to be some sort of, fair or not, that there might be some bias for the home state resident. So we have diversity jurisdiction. There are other cases where, you know, for example, if you're challenging some of the Obamacare litigation that's taken place, because that's a federal health system, you know, that takes place. Federal questions that arise under a federal statute, Title VII, discrimination suits, that sort of thing. Those are the sorts of things. Now, state courts are actually courts, what are called courts of concurrent jurisdiction. So we can actually hear some federal claims in the state court. But no matter what we hold, ultimately, on matters of federal law, the Supreme Court of the United States is the court of last resort as to federal law.
So there's kind of, I mean, it would take a long time, I think, to exactly
actually
go through the way the legal system works. And to me, the simpler it is, the better. But in any event, you're in this position where you hear appeals from mostly the superior courts. Is that correct?
That's right, mostly from the state trial courts.
And you would not be, as I understand this, a trier of fact. Did I get that right?
No, that's right. That is not the job of an appellate court. In appellate courts, we give, unless the findings of fact made by the trial court are clearly erroneous from the record, we give great deference. We're there, and I always explain it this way to lay folks. We're there to essentially be a backstop. We're there to ensure that there have been fair proceedings below, and in my view, to be a guardian of the what I call the corpus juris, the law, to make sure not only that we get it right in that case, but that we're also making sure that we are writing decisions, interpreting the law that allow businesses to manage their expectations, that allow citizens to make sure that they live their lives in such a way that we want to, I don't want to just write opinions for lawyers. I try to write opinions where anybody of average intelligence can pick it up and understand what's going on in that case.
Now, it's common to see after a particularly, I guess, tense trial, the TVs or cameras are there, and the lawyer for the defeated party would say, I'll appeal. This is my client has been wronged. I plan to appeal. And then that's how successful are these appeals, and just how is there a percentage of times that the lower courts are reversed? Do you keep track of that?
Yeah, we do. We have numbers on all of that. We have direct appeals. We have appeals that take place while the trial's still going on. They may say, hey, judge, to the trial judge, hey, judge, we want a timeout. We think before we go any further, the appellate court ought to step in and rule on this issue, whether you got this right. Because if you got this wrong, then we shouldn't even be going to trial. And so, yeah, I mean, I think it's as far as the percentages, I would say for the most part, from what I can see in civil and criminal cases at the Court of Appeals, I would say roughly a third or less of, maybe third's a little bit high, maybe somewhere around 26, 27% of the cases we get are reversed. So there's a lot of cases being affirmed.
Now, so in the course of your day, maybe you can just describe how the court is functioning on sort of a daily basis. You're apparently not in, if I can, what's the word? It's session. Maybe that's the wrong turn of phrase. But you actually meet not all the time around the year. and then you have clerks.
I don't wear my robe a whole lot.
Right,
I mean, a lot of what I do, unlike my friend Tripp Self, he's on the bench a lot, and he's actually conducting trials.
Yes.
When it comes up to our court, we get a paper record, soon to be a digital record.
Right.
And we get that record, then we get what are called briefs, and in those briefs, they take all, you could have a 5-week trial.
Yes.
This long trial, all these resources, and it might come down to 2 issues.
Yes.
And so we are looking very narrowly on only those issues. We're not looking through the entire trial trying to figure out all the different errors.
Yes.
We're only looking at the errors being complained of by the parties. And so we're focusing, we're doing a very narrow focus to see whether or not, like I said, there were fair proceedings below, or whether there was some error in the application or interpretation of the law that took place at the trial court level. That's really our job. And so as far as oral arguments go and actually sitting on the bench, that only comprises about 10 to 12% of all of our cases.
Yes.
The vast majority of our cases are decided on the briefs. We read the briefs, we do the research. There's a lot of back and forth between the judge and his or her law clerks, and we debate things, we hash it out, but a lot of it is writing, researching, and talking with one another, and using, and with other judges, and kind of informal conferencing to figure out whether these decisions are right. But all that is not usually taking place in public. Now, we do have oral arguments.
Right, yes.
I think that's important for transparency.
Yes.
But because we're so busy, we have to minimize. We can't have as many oral arguments as I think as we would like.
Yes.
Because we're one of the busiest appellate courts in the country right now, even with 3 new judges that we recently.
Well, let's discuss that. One of the fortuitous things that have happened in the Empire State of the South is we have a large population expansion.
Right.
I mean,
10 million.
I've heard 10.5. I've heard it, counting everyone, like huge population increases.
That's right.
Millions of people here, and they say, 50 or 60 years ago, the population of the state was 3 million. So we have this tremendous increase in people in the state, and also maybe more legal disputes have arisen in our mercantiles. So you have lots and lots of business. Now, how do you handle all the increased load? I understand there have been some recent changes.
There have been.
Can you discuss that? What's happening?
We started with 3 judges in 1906. One of the reasons they created the Court of Appeals was one of the Supreme Court justices at the time was very well known, ended up quitting the job out of exhaustion.
Yes.
So they created the Court of Appeals, 3 judges, and it's grown over the years. In fact, the most recent, until last year, was in 1999. They added 2 more judgeships, which increased it to 12.
Yes.
Which was 4 panels of 3.
Right. Yes.
And then last year, the General Assembly and the Governor Deal signed this legislation creating 3 new judgeships. So we're now at 15.
Yes.
There's some discussion that the Supreme Court might be expanded from 7 to 9, which is what the Supreme Court of the United States has. And the reason for all of this is because we have 10 million people. Right. The Supreme Court has been at 7 for a long time.
Yes.
The Court of Appeals is now at 15, but even at that, the question is at the appellate level, you really want judges spending a greater deal of time on appeals and not having to feel like they're triaging cases so that they can write opinions, they can publish those opinions, and once again, so businesses can kind of figure out, okay, how do we operate? And when some of these difficult issues aren't being addressed because there's just simply not enough time, and you're having to get out the opinion to get the result correct in that case for those parties, that's important. That's one of the number one things, most important aspects of our court is we want to get the case right for those parties, because those parties have litigated. They want an answer, and they want that answer to be right. They're not always going to agree with us, but we want to make sure it's right. But the secondary, and also just in my view equally important function of our court is to make sure that we're putting out coherent, clear, concise, stable case law, so that we can function, as a society, so that we do have the rule of law, that we have opinions that explain how all these statutes that are passed by the legislature or how our Constitution, what it actually means in our daily lives, the application of those constitutional, those cherished, principles from our founding as a state, how do those actually work in real life?
Now, the structure of, I think many places, the Constitution, the state Constitution, would pass some kind of, I guess, give you guidance about how the appellate court system would work, how many judges there would be, this and that.
Right.
Is that the case in Georgia? Do you require, presumably not, a constitutional amendment?
Well, right now, my understanding is that the Constitution allows the Supreme Court to go up to 9. I think after that we would have to amend the Constitution.
Yes, yes.
My understanding about the Court of Appeals is I think we can go up to 18. I think after that we would have to, amend the Constitution to go beyond that. So we've got a little bit of room. I don't know that we would ever really need to go beyond 9 for the Supreme Court. The question at some point is, do we need to add more judges to the Court of Appeals? Do we need to consider alternatives about splitting the Court of Appeals, like some states where you have a civil Court of Appeals that only handles civil cases, a criminal Court of Appeals that only handles, or whether we go to districts where we have a Macon division, a Savannah division, maybe one in North Georgia, one in Atlanta. I hope we don't do that. I like having a unified Court of Appeals with panels, and I think we're doing some changes right now and planning for the next 50 to 75 years in hopes that we're not going to have to, that we can keep that unified system, because I really enjoy handling both civil and criminal appeals. I find both of those areas of the law fascinating.
So, just to pick a number, about how many cases a year would to use this term of phrase, dispose? How many cases would be disposed by the Court of Appeals? You'd look at 1,000 different, cases would come before you. It must be a big number. Or?
It is, and it's on the website. I don't have the exact number.
It's a big number.
Here's what I can tell you, though. Just for me, on average, since I've been on the Court of Appeals, I am assigned to author about 150 opinions a year.
Well, that's a lot. It's like 150 papers. It's quite a.
That's
a lot.
Quite
daunting.
Now that's just my author as the author.
Yes.
I'm also that's just the ones that I'm initially assigned. I also am required to vote on the 300 cases from the other 2 judges on my panel. Yes. I'm also required to vote on any cases where I'm having to participate in the whole court that might go beyond my panel, which happens. I might have to, if one of those cases rolls over to me and I'm dragged in, I might have to write on those cases.
Yes.
I have motions I have to handle every day. I have applications for people wanting to appeal when they don't have a right to appeal, asking us for permission.
Yes.
I have interlocutory appeals where people are asking, hey, halt the proceedings below and let us appeal now after review those applications. And, there's all sorts of other administrative and ceremonial functions. So, you've really got to have your time management down to serve and effectively serve on the Court of Appeals. It is, if you are doing the job correctly, you're spending some time on the weekend in addition to the week getting everything
it sounds
done.
like a really.
And we're never unlike the Supreme Court of the United States, we're not taking off the summer. Yes. I mean, we really are. Right. We might take maybe some judges might take a cool down period right after we have one of our deadlines.
Right.
But that's only for about a week.
Right.
And even then, you're still processing some of the smaller items.
So when you write these opinions, they're often not terse. In other words, that's really quite an intellectual mountain to climb, isn't it? To write an opinion that's it's no small task. It's not a one-word mission. You really have to probe the issues involved, and it's quite complicated.
You do, and I think it's important to be respectful of your colleagues, and when you have disagreements, to disagree in a reasonable and respectable way. I mean, you have to always remember that you as a judge, you are, I hold a certain seat, and when I'm dead and gone, somebody else will hold it. Or when I'm, if I ever leave the bench, somebody else.
Yes.
And so you're part of kind of a continuing American jurisprudential tradition.
Yes.
And so you want to make sure not only that you're respectful of that role. I mean, I'm cognizant of how important I'm playing a small role in that history and that tradition, but to me it's very important that I, whether it's in my opinions or in how I act, that I'm always upholding the integrity of the office.
Yes. Now, in general, the lay public has heard the stories about, particularly in regards to the U.S. Supreme Court, that well, the court is writing the law, they're expanding the what's the intent of the Constitution, or some people would say the court's job is just a narrow viewpoint about what's really in the Constitution.
Right.
Does that play itself out in your part of the world? I mean, is there that kind of discussion?
I think it does. I mean, I think one of the most important things a judge needs to understand, and I was on the Judicial Nominating Commission before I became a judge, so I was actually interviewing people that we would send to the governor for judgeships. And one of the things I always wanted to probe was, what does it mean to you to be a judge?
Yes.
What do you view your role as the judge? What function do you believe does the judiciary play in the separation of powers?
Yes.
As for me, I don't make any bones about it. I'm a judicial conservative. I'm a textualist. I believe that the words passed by the General Assembly have a reasonable range of meaning. It's my job to apply those, to give a fair reading of those words and to apply them to the facts of the case, whether I like the result or not.
Yes.
As for the Constitution, I believe that my job is to understand the original public meaning of that document, understanding obviously that I have to follow the precedent of both the Georgia Supreme Court and the Supreme Court of the United States, whether I agree with it or not, because we have a hierarchy. And the rule of law requires us not to be anarchists as judges.
I see. And so you mentioned panels. Just so, I mean, I'm making the comment, 15 judges sounds like a lot.
Right.
So you subdivide thing into panels. What exactly?
Three judges. Right.
What,
so we have
how do the panels? How does that work? If I could
so the way it works is a case comes in and it is assigned to a judge to author who is already on a panel. So for this upcoming year, for this year, I'm on Division 5. With presiding Judge Phipps, I'm next, and then a newly appointed Judge Peterson. The three of us sit together for a year, and we have cases assigned to our panel, and it's equally distributed among the three judges. And so I'll write up my cases and circulate it to the other two judges. They have to sign off on that or dissent, and then we go from there. Or I mean it's a collaboration between the judges on the panel. But when we decide something, if we decide a case unanimously, then those three judges speak for the entire court. And if you want to overrule that case, you have to go to 15.
Oh, is that right? I see.
Yeah. So that's one of the ways that a court of appeals, an intermediate court, can be far more efficient than the Supreme Court of Georgia, where all 7 have to constantly vote on everything.
Yes.
So they've got to have 7 people look at to decide a case. We only have to have 3.
So the cases go from the Court of Appeals to the Georgia Supreme Court for additional, I guess, purview.
If you're granted a writ of certiorari, you have to ask permission.
From the Georgia Supreme Court?
From the Court of Appeals to the Georgia Supreme Court. If you don't like the Georgia Supreme Court, you have to go to the Supreme Court of the United States. If it's a federal issue.
Yes.
If it's a purely state issue, the Supreme Court of the United States is not superior in that respect to the Supreme Court of Georgia. If it is purely an issue of state law.
So cases do go to the Georgia Supreme Court. When you mentioned the process by how cases get there, the preponderant number of cases would go through the Court of Appeals.
That's right. 83% of all appeals come through us.
So you would go through that, and then the idea would be, all right, some number would go to the Georgia Supreme Court.
Yes, they get some cases directly, too. They get death penalty cases.
Yes.
Right now, they get title to land cases. They get divorce cases.
I'm
election
chuckling slightly.
contests.
Title to land?
Well, that's one category they're talking about shifting to us as an original matter. So, but they get death penalty. They get any kind of constitutional challenge to a newly enacted statute or a statute, that would go to the Supreme Court of Georgia. They get murder cases. They have exclusive jurisdiction over all murder cases. And so there's all sorts of equity, like I said, election contest, title to land, all of those cases go. And so the idea that we're looking at in the future is to shift some of those cases. They would come to us first. And then you would have to ask for permission to go from the Court of Appeals.
Now, some percentage of cases must be reversed. I mean, there must be some percentage. And
Sure.
So how does that work, and how would you respond to a reversal by the, what happens? I mean, the Georgia Supreme Court says, well, you guys, we find it the other way.
Right.
And so what's the response to
I've got a pretty good batting average up there. I've only been reversed once. And
that's pretty good.
It was relying on one of my court's prior precedents. But that said, when they reverse me and it comes back, it's simply my job to say, Yes, sir. Yes, ma'am.
Yeah, right.
Yeah, the Supreme Court has spoken, and we now incorporate their judgment as our own.
Yes.
That's what's called vertical stare decisis, meaning that the precedent of a higher court binds the lower court.
Yes.
We have horizontal stare decisis, which is, I certainly can reconsider my court's precedents.
Yes.
But I can't do anything about precedents vertically of the Supreme Court of Georgia or the Supreme Court of the United States.
Yes. Well, Judge, it's been a real pleasure having you here tonight. Just speaking as a layperson, I feel reassured about the way the justice system works.
Thank you.
Do you have any final comments about how you see the future? You mentioned some of the changes that might happen.
I will say I'm very pleased the last 5 years with the direction of the Georgia appellate system. I think a lot of former federal clerks are coming into it, very experienced Superior Court judges, and we even got a DA this last round of appointments. So I really think the people of Georgia should be very confident in the types of judges that have been appointed by Governor Perdue and Governor Deal. I hope that year by year we are becoming a more efficient, more professional, and a court that Georgia can be proud of. We've done some great things in the past, but I'm really excited about where we're heading in the future.
Well, thank you so much for being here. It was a pleasure talking to you tonight. Thank you, Judge. Thank you.
This program is brought to you by the Georgia Neurosurgical Institute. For over 50 years, rendering neurosurgical care to patients of all social conditions, treating complicated problems involving the brain, spine, spinal cord, and peripheral nerves, endeavoring to encourage quality care, medical research, innovation, and education on a local, national, and international basis.